Many taxpayers believe that leaving California automatically ends their California tax obligations. That simply is not true. California residency audits don't turn on what you say or what you put on a tax return. They turn on whether your actions match your intent. And when the Franchise Tax Board starts examining your electronic footprint, they're looking for evidence that tells a very different story than what you filed or what you said. Hi, I'm David W. Klossing. I'm a dual licensed tax attorney and CPA, and I'm the owner of the tax law offices of David W. Klossing. Today, 24 offices, 11 states. Today, we're going to discuss how California residency audits really work, what evidence decides your intent, and how taxpayers can safely defend against aggressive FTB residency challenges. So, why does California audit residency so aggressively? Well, it turns on this. California taxes residents on their worldwide income. Make a buck anywhere in the world, they tax it. That means if the state determines you remained in California as a resident, they may tax income earned on you anywhere in the world. This is why residency audits often involve high-income taxpayers, business owners, and individuals who recently moved out of California. California doesn't rely on a single factor to determine your residency. Instead, the FTB evaluates all of the facts and circumstances, and that's where many taxpayers and frankly their representatives run into trouble. California defines a resident in two main ways. First, someone who is in California for other than a transitory or temporary purpose. Second, someone domiciled in California who remained outside the state, but they're outside for what California deems a temporary or transitory purpose. That's where they get you here. This means you can leave California but still remain a California resident for tax purposes. Your intent becomes critical in this determination. And intent is measured through your actions, not your words or positions taken on tax returns. Your electronic footprint is the real problem here. Where are you buying gas? Where are you paying your utility bills? Where are your credit card transactions occurring? Where are you buying your tacos on Taco Tuesday? Where are you actually spending your time? These type of contemporaneous records carry much more weight than any self-prepared calendars or any statements you could make. And when your footprint contradicts what you've claimed, the FTB often uses that to challenge residency. So let's talk about domicile and closest connection. California residency disputes often revolve around domicile. Domicile is your true, fixed, and permanent home. And California makes the assumption you retain your domicile until you establish a new one outside California. This requires leaving California, establishing a new primary residence, and demonstrating intent to permanently and indefinitely remain outside California. If your ties to California remain stronger than any ties out of the state, the FTB can reach a conclusion that you never truly meant to leave. So here's the common evidence the FTB looks at here. First of all, they look at your physical presence. They look at your housing arrangements. They look at the location of your family and how often you're visiting. They look at your credit card activity. They look at your driver's license. They look at your voter registration. They look at your professional licensing. They look at your medical providers. They look at your social and business ties. What matters most is not the number of ties, but the strength of each tie. If your life still revolves around California, the FTB may conclude you remained a California resident, even though you're living outside the state. California offers a limited safe harbor for certain taxpayers who leave California under employment contracts. Under this exception, if you remain outside California for at least 546 consecutive days, you may qualify as a non-resident. However, be forewarned. This safe harbor has very strict requirements, and many taxpayers fail to qualify under them. Well, one of the biggest mistakes we see taxpayers making and their representatives is trying to reconstruct records after an audit has already begun, creating calendars after the fact, backdating documents, fabricating proof. If you do any of that, you can dramatically increase your risk. Okay? California can treat these type of evasive actions as evidence of criminal intent to evade California taxation. This is why strategy matters here. Residency audits are not persuasion exercises. They are document and evidence-driven investigations. Your defense must show abandonment of California ties, establishment of stronger ties outside the state, and present a consistent timeline supported by third-party records. Without strategy, taxpayers often expand the dispute and increase their exposure. So in closing, if you're facing a California residency audit, early planning is critical. At the tax law offices of David W. Klossing, our dual license attorneys and CPAs build evidence-based defenses that match your intent. Call 1-800-681-1295 or visit klossing-associates.com to schedule a confidential reduced-rate initial consultation today. You won't regret it. Dave Klossing, tax attorney, CPA.